Now let's start with the third one. Role in lawmaking. One of the functions of judiciary is to make laws. Okay, how? We discussed this very briefly in the last class. Tell me, how does the judiciary play the role of a lawmaker? It is the mandate of the legislature, right? Lawmaking is the duty of whom? The legislature. But it says judiciary also plays to some extent the role of lawmaking. How?
Ma'am, there are a few, judiciary take, like, there are few laws which have to be made quick, I think. So, like, the
I can give
judicial.
you a hint.
Yes, ma'am.
Vishaka guidelines.
Vishaka guidelines.
Okay, let me repeat. See, judiciary sometimes can act suo motu. Suo motu means on its own. Sometimes on the petitions filed by the citizens. Okay, on the petitions filed by the citizens. How can it act suo motu? For example, let's say something is happening in the society, in the political setup in the state, but the state does not have the, let's say, time to look into it, or maybe it would be just too late to wait for a law. The Supreme Court in that situation can, or in those situations, can come up with some rules which will act as laws. Okay, which may not be exactly same as laws, but would be acting as rules, as laws. Is this clear or not? Let me give you an example. Let's take the example of enforcing seat belts. Now, if you don't put a seat belt while driving, you may have to face a challan. Yes, seat belt is mandatory. Who regulated this seat belt culture? It was the Supreme Court. It wasn't the legislature which came up with a law to mandate or to make seatbelt wearing mandatory, but in fact, it was the judiciary. We call this, side of the judiciary to be judicial activism. What is judicial activism? When judiciary becomes active in taking measures in the areas where the legislature has still not legislated.
So, like, even wearing a helmet is also
Yes,
mandatory. Is
yes,
that made by the
yes, the judiciary.
judiciary?
Yes. Okay. For example, directing the Delhi government, Delhi government to come up with some measures to control the pollution in Delhi in winters is also something that the judiciary came up with. Though it only directed, then the government came up with its grade planning.
So, like, judiciary makes these rules or laws based on what the public has to say about it, or they make it on their own without the public being involved.
See, they can act both ways. They may take the decision suo motu, that means on their own. If they think something is going wrong and we should do something about it, they may take up the issue suo motu on their own.
So, like, they don't have to consult the legislature.
They don't consult the legislature, they actually direct the legislature. Okay, they don't consult them. See, first of all, the judiciary can take the decision suo motu, plus the judiciary can take the decision on the basis of some petition filed. I'll give you one example. And sometimes, see, it's not necessary that the judiciary will take decision. Certainly it may simply ignore the petition. I'll give you one example. Let's say one individual, in fact several petitions has been filed, but one such petition was to direct the judiciary, or to ask the judiciary to change the article 1 of the constitution. Article 1 defines India. Okay, India, that is Bharat, shall be a union of states. It goes this way. Now they said India name should be removed. only Bharat should be left there. Now, this was a non-sensible petition. The Supreme Court rejected this simply, right? But when there were petitions for the Supreme Court to come up with some kind of rule, some kind of guidelines to prevent sexual harassment at workplace, the Supreme Court did consider it, and the Supreme Court came up with the Vishakha guidelines. Is this clear? So Supreme Court is not bound to act on the petitions filed by the people. If it founds them to be,
Sensible.
time wasting, non-sensible, then it may reject them as well. Because obviously we have crores of cases pending in the judiciary, right? And there is a lot of, I will discuss later on, there is a problem of shortage of judges as well. So many vacancies are there in the judiciary. It is said, I don't remember the exact facts, but nearby 53% seats are occupied by the judges and almost 47% seats are vacant. So the judiciary overall in India can be called to be slow. Okay, and when we have so many cases pending with so many vacancies, and along with the slow pace of the judiciary, we cannot waste our precious time on addressing the non-sensible petitions. So the judiciary is not bound, but it may take the matter suo motu, and if people are filing petition and it thinks that this matter is worth considering on, it may take up that issue. Okay, so now the judiciary many a times have formed some rules. Plus one more thing is, if let's say the judiciary, the higher judiciary, who is the higher judiciary? For high courts, it is the Supreme Court. For district courts, it is both the High Court and the Supreme Court. So higher judiciary, if is giving some judgment, the lower judges, the lower judiciaries are actually bound. The lower courts are actually bound to act in accordance with the judgment given by the higher court. Let's take an example. There was this K. Puttaswamy case in 2015. K. Puttaswamy case in 2015. In this case, the judiciary declared right to privacy as a fundamental right. Right to privacy is a fundamental right.
So like right to privacy came in 2015.
Actually, see, understand this thing. I'm answering your question only, but understand the whole thing, and then you'll get the answer to your question. Okay. Right to life is there from the very beginning, from the inception of the Constitution. Now, what is the meaning of right to life? This definition has been evolved over years. What is the meaning of life? Earlier, we might have been thinking life to be just taking breaths, but slowly and steadily, the judiciary gave additional values to it. The judiciary, over a time, has basically defined it as not just breathing, but a life with dignity, with basic material things, and with dignity. So it said life here doesn't mean simply to take breaths, to being, to just be a living being. No, it's about living a life with dignity. So in many cases, let's say in one case, the judiciary said right to life is not just about taking breaths, it's about living a life with dignity. In one case, the Supreme Court said, if we are talking about dignity, then you cannot, let's say, if you are just accused, if you are not proven criminal, if you are only accused, the judiciary, the police cannot put in your hands these handcuffs. Because you are simply accused. You are not proven guilty yet. Okay, so you in handcuffs would mean you are being indignified, which is against your fundamental right. So the judiciary said you have the right, a citizen has the right against handcuffs. You know what handcuffs are? Hatkadi. Hatkadi, yeah. Because if you're not proven guilty, how can somebody lock up your hands? It would be very indignifying. Then the judiciary said right to life includes right to livelihood as well. Then the judiciary slowly and steadily said right to life includes right to privacy as well. Okay, so in 2015, judiciary said right to privacy is inherent in right to life. Now, what is right to life has been evolved over years, and that's why we say judiciary interprets the constitution. It's not written in the constitution. It has just, viewed judiciary. It has just looked into not judiciary. It has just looked into the article with some additional values. That's how they evolve it. They interpret it. And whenever you need to, you means the judiciary, whenever you need to interpret the constitution, you have to appoint the constitutional benches. There are special benches in the judiciary which interprets the constitution, and we call these benches to be the constitutional benches. And the minimum number of judges required in these constitutional benches are 5. Okay, and they are in odd numbers, 5 or 7 or 9 or 11 or 13. Do you know the case which have the highest number of judges till date? This is a constitutional bench, and it has the highest number of judges sitting to interpret some parts of the constitution. This question was asked in KBC, and this was a question worth 1 crore, I think, or maybe 5 crores. I think it was worth 1 crore. Tell me, which is that case, which has the highest number of judges till date? It was the Keshwananda Bharti case. Okay, we'll discuss later on when it will match some part of your syllabus. We'll discuss this case, what it was, but it was related to land reforms. Okay, there were some people who did not want to give away their lands, but the government said now there is maximum ceiling. You cannot keep land beyond this amount. So any amount of land beyond this limit would be forfeited by the government, and these people were against this forfeiture. They said, why should we forfeit our land? This is our land, and right to property is a fundamental right. So this was the case. Finally, the judiciary said land reforms. Yeah, should I start?
Yes, ma'am.
Yeah, so the judiciary finally said land reforms will be imposed, but I'll discuss in detail what this case was all about. But it was Keshwananda Bharti case. You can write this question if you want.
Okay, ma'am.
Write down which case, wait, right? Which constitutional bench which constitutional bench has had the largest number of judges, till date. The largest number of judges till date. The answer is Keshwananda Bharti case. Keshwananda Bharti case. This Keshwananda individual died last year only. Though this case was filed in 1973. The judgment came in 1973 actually.
Keshwananda. So like, was he a judge or something?
No, he was not a judge. Actually, he was the owner of a mutt. You know what a mutt is? It's a religious ashram-like place. Okay, and it was a religious place in Kerala, and it was huge in size. And the government had brought in land reforms, and one of the laws within these land reforms was the Land Sealing Act. That means putting a higher limit on the amount of land that you can. Uh, it was Land Sealing Act. The uh, This act imposed a higher limit on the amount of land that you can have. You cannot have beyond this. You can have anything below this, but not beyond this, above this.
I'm like, so mutt meaning, did he have a place to stay where his
Yeah, he
laws
would
allowed?
stay there. I think he would give some spiritual lessons there. It was
Oh,
like an ashram, a religious place basically, where monks would live. Perhaps I'm not sure about it. Pardon if I'm wrong, but it was some kind of religious place like an ashram. Okay, that's what I know. So because I haven't actually researched about this mutt, what exactly was it? But it was some religious place, that was for sure.
okay.
So it was a religious place, and the land at which it was constructed, it was built, the setup was built, was exceeding the maximum limit set up by the government. The government had set up a maximum limit. You cannot go beyond this. You cannot have land beyond this, but you can have anything less than this. So the government said, since the mutt is covering a land area which is above the land ceiling, the government will have to, the officials will have to forfeit this excess land, which is beyond this limit, will have to forfeit this land. Okay. And this individual filed a petition, and there was a very famous lawyer actually in those days, Nani Palkiwala, who fought for this individual, and many such cases were filed in the Supreme Court. They said, you are saying right to property is a fundamental right, and at the same time you are forfeiting our land. So which holds more weightage, your land reforms, your land sealing act, or the fundamental right? Actually, Land Sealing Act was brought in to bring in equality of wealth. What would the government do by forfeiting this excessive land? The government would redistribute this land to bring in equality of wealth in the economy. Okay, which is in alignment with one of the chapters of constitution only, which is directive principles of state policy. Now, what is the meaning of directive principles of state policy? It is actually a combination of so many articles which would always be directing the government in their policy formation. Some values, some principles have to be kept in mind by the legislators when they would make some laws. Is this clear or not? So directive principles are not enforceable. If the government, let's say, is not in alignment with a particular DPSP, you cannot go to the court and file a petition against the government. No, you can't do that, because DPSPs are not enforceable in the courts of law. On the other hand, fundamental rights are enforceable in the courts of law, so much so that you can directly go to the Supreme Court. I told you can go to the Supreme Court under Article 32, and you can go to the High Court under Article 226 in case your fundamental rights are violated. So actually the debate was, who has got more weightage? Is it the fundamental rights, or are these the DPSPs? Who have got the more weightage? Actually the parliament removed fundamental right to property from the fundamental rights chapter, and they had written it separately in Article 300A. Basically, right to property due to these petitions was taken out from fundamental rights chapter and was put in the 300A. That means it was made a simple constitutional act. Before this, it was a fundamental right.
So like, did this Keshwananda Bharti win the case?
No, she lost the case. He lost the case. Why did he lose?
Because it was moved.
Because income inequality was very necessary at that time. Okay, the judiciary could be convinced by the government that it is high time that we implement these laws. Otherwise, we would have, extreme inequality in the economy. But the judiciary gave a very important judgment in this case. The judiciary said the constitution has got a basic structure. You cannot change the basic structure of the Indian constitution. The parliament can do anything, can change the constitution, can bring in amendments to the constitution, can upgrade it, but cannot degrade the basic structure of the Indian constitution. It can add or subtract something from the constitution, but it should not affect the basic structure of the Indian constitution. Now, what is this basic structure? See, let's say you have to design a car. तो आप क्या पहली बार में ही पूरा उसका कलर सब कुछ डिजाइन कर देंगे? नो, you'll design the basic structure, right? You'll design the basic structure of it. On the basis of this basic structure, will you add on other things? For example, if you are to construct a home, if you are to
So
construct,
like if government would have made him win the case, that means they are going against the equality part of the constitution.
yeah, but in equality, yes, you can say. See, the judiciary actually had two branches of arguments. They had some things which went in favor of land reforms, and there were some things which were against these, and the judiciary found implementing these to be worthy, okay, net worthy, and the judiciary gave go ahead to these laws of the parliament. But understand, in this case, the judiciary gave the most important judgment, and then that is the basic structure. The judiciary said the parliament can do anything to the constitution, but cannot change the fundamental structure, basic structure of the Indian constitution. And there was in fact a question in civil services last year. The question was, is this basic structure defined in the Indian constitution? Is this basic structure defined anywhere in the constitution or even in any other law? No, it has not been defined. Basically, the judiciary on case to case basis decides whether this is the basic structure of the Indian constitution or not. For example, in one case, judiciary said secularism is the basic structure of the Indian constitution. You can bring in changes in the constitution, and you can bring in fact any law, but you cannot make any such change to the constitution which may negatively affect or harm the secular principle of the constitution. Are you getting my point? So this judgment is known to be one of the 4 or 5 landmark judgments of the Supreme Court. Why? Because every time the parliament comes up with any law which affects the basic structure of the constitution, the judiciary says this affects the basic structure of the constitution, struck this down.
Ma'am, one more question, ma'am.
Yeah.
For example, if a person murders someone,
sorry, can you please repeat?
If a person murders someone and and that person is guilty, so will he still be able to be like? Can he still be like bailed out of the thing of the like? Can he still be bailed out?
Can he still be bailed out
even after being guilty of murdering someone?
Generally, it's very difficult, but yes, one can be bailed out.
Okay, that's very.
There are loopholes. Okay, there are loopholes, but
on what basis? That's
on what basis? Let's say if somebody proves it to be, a murder. Sorry, if one proves it to be a reaction for self-defense.
Okay.
Right? Killing someone for self-defense, according to our laws, is not a crime. If you can prove that you were defending your own self, then you can be proven. You can be actually released. You can be bailed out. It's difficult if charges are, stringent. If the charges are crucial, stringent, then it's difficult to get bail. But see, I'll tell you, there's a lot of subjectivity of the judges in case to case. I'll give you one more example. There was a case, I think this case was Balwant Singh case. A man from Punjab who used to beat his wife and sexually harass his own daughter. Okay, and he was jailed. He was jailed, and the judges had sent him on parole. Parole is a kind of break that you get from the jail. You can come home, you can stay, but you cannot leave the city. Are you getting my point? You get parole midway. So he was on parole, and he raped his daughter, and I think he killed his wife. Okay, and he was again arrested, and final decision in this case was life imprisonment to Balwant Singh, not capital punishment, not execution, not death penalty, only
Life in prison.
life sentence, life imprisonment. Why? Because this was not the rarest of the rare cases. The judiciary has said capital punishment can be given, death penalty can be given if the case is rarest of the rare cases.
Ma'am, now what will that be?
That depends on the judiciary. Now I'll tell you, wasn't this rarest of the rare cases?
Ma'am, like it's
No, just let me just finish. I'll come to you. Let me just finish. Wasn't this rarest of the rare cases?
ma'am, it was rare.
It
Rarest
was,
of
but
the-
maybe according to judges, it was not. Then the same judge's bench heard another case. In this case, a boy was kidnapped, okay, and was murdered. And he was, I guess, a single child, or maybe a single son. Maybe other sibling was a girl. Okay, and the judiciary, the same bench said, look at the plight of the family of this boy. See, I'm not saying it was a very non-serious case. It was.
But
But the
leaving the
first
other
case
case,
was
yes, ma'am.
no less.
Yes, ma'am. That's true.
And the kidnappers, the murderers were given execution, death penalty. Now the same bench, the same number of judges, the same judges were sitting in the first as well as the second case, with not much difference in time and space as well. But the first case was not rarest of the rare, and the second case was rarest of the rare. So there's a lot of subjectivity as well. And I'll tell you what I could see in this case, in this difference, was a lot of patriarchy that has been still ingrained in our judiciary. Okay, because this was a boy child. Okay, and look at the plight of the family. They have lost their only son. This was the judgment. This was the comment that came in the judgment. Look at the plight of the family. They have lost their only son. But that case was not rarest of the rare, where a father had raped his daughter,
Yes, ma'am.
murdered his wife.
Thank God he was not out in the public, or else,
Who?
ma'am, the first case on the
Yeah.
person. Else he
Yeah.
would be killed by the
He must
public.
have been executed. Okay. I generally don't support capital punishment, but there are some areas where capital punishment should be there.
Yes, ma'am.
When it's about rape, I think capital punishment is the only solution.
Yes, ma'am.
But in all other cases, I think a person can be rehabilitated, But in case of a rapist, I think no mercy should be given.
Yes, ma'am. That's true.
Yes. Next is, okay, so we have done role in lawmaking, and then is equity legislation. Equity legislation. See, sometimes you have so many laws, okay, Lobs, and you have so many laws, but sometimes you may not come across a particular law to deal with a particular case. You may not find any legislation to deal with a particular issue. For example, almost about the first decade of the 21st century, we didn't have any rule. It was only in 2008 we came up with this POCSO Act. I guess it came in 2008 or 2013. I think it came in 2013. There are two laws. One is Sexual Harassment at Workplace Act, prevention of sexual harassment at workplace. Second was the POCSO Act. Let me just see when they come. Okay. Before at least 2008, there was no such case. Okay, there was no such case to deal with this problem. But wasn't this problem there? Wasn't this problem there? Weren't women being sexually harassed at workplace? They were. Okay, but there was no law. So in case when there is no law in place to deal with a particular issue, or when there is an act but it is very ambiguous, it's abstract, it's not clear, in that case the judiciary can give its own judgments to fill the void which has been created due to the absence of an act or abstractness of an act. Are you getting my point?
Yes, ma'am.
Yeah, so that is what we call as equity legislation. So if the act is not there, the judiciary is taking initiative to fill in that void and give its judgment to compensate that absence or abstractness of a law. Next is protection of right. This we have already discussed, but one thing that I want to discuss in this is there are two ways, to give out judgments. One is due process of law. Okay, one is due process of law. Write down what is the meaning of, or explain the principle. Right this way, explain the principle, quote unquote. What is the meaning of quote unquote due process of law? Due process of law. Due process of law. Write down the definition to this. Write down. Due process of law is a doctrine. It is a doctrine. It is a doctrine that not only checks if there is a law to deprive the life,
Not only checks.
that not only checks if there is a law to deprive the life and liberty of a person,
Yes, ma'am.
but also ensures that the law is made fair and just.
Yes, ma'am.
See, in case of due process of law, it's a doctrine. Its belief is, how it works is, it considers the law, whether a law is taking away your liberty or not. Okay. The second thing that it looks into it, that the law must be fair and just. Is this clear or not?
Yes,
There
ma'am.
is another doctrine. We'll compare and then we'll understand it better. Write down the second question. What is quote unquote procedure established by law?
What is the
What is the quote unquote procedure established by law? Procedure established by law. Write down. It is a doctrine.
wait, ma'am. Uh,
It is a doctrine
It is a doctrine.
which means that a law is duly enacted. Which means that a law is duly enacted by the legislature. By the legislature or the concerned body is valid only if the correct procedure has been followed, only if the correct procedure has been followed to the letter. See, understand, due process of law focuses upon the law, whether it is justifiable or not, whether it is correct or not. Is this clear?
Yes, ma'am.
Procedure established by law focuses on how have the law been enacted, or how have you carried out the whole case, whether it was in accordance with the law procedure, whether it was accorded with the law, or have the procedure been against the law. Let me give you the example. Let's say an individual has been found guilty of consuming narcotics, okay, smuggling narcotics and selling it illegally. Now, if you're following due process of law, the judiciary is only concerned about whether the Narcotics Act, prevention of consumption of narcotic substances, etc., act is correct or not, okay, and are you really guilty under this act, and will give its judgment. But if you're following due process of law, the judiciary will also look into how have you been, found guilty. Will look into the procedure, whole procedure. Are you getting my point or not?
Yes.
You see, it's actually wide. Okay, it looks into the wider picture, right? Let's say if let me give you one more example. Let's say if somebody is engaged in some kind of human trafficking. Okay, someone is engaged in some kind of human trafficking. Now they have been arrested. Okay, this woman was there who was you know basically leading this whole racket of human trafficking, and this woman has been now arrested. Now if you are only following due process of law, you look into, okay, they were actually violating article 22 23 of the Indian Constitution, and they are guilty, and they are supposed to be punished. They are guilty under some sections of the IPC, and this provision of some act. But if you're following due process of law, you'll also look into how these women have been arrested, because you cannot arrest a woman in exceptional situations without the permission of the magistrate. You cannot you cannot arrest a woman after 6 p.m. and before 6 a.m. without see, the moral code of conduct is you should not arrest a woman after 6 p.m. and before 6 a.m. Okay, and but if you think that it is necessary to arrest this woman, otherwise she may cause harm to people or the society in general, then a women officer should be there. A women police officer should be there. But in case you cannot manage that as well, that you need to take permission from the magistrate, special arrest warrant from the magistrate, only then can you arrest a woman in the night hours or in the late hours, 6 p.m. and 6 a.m. between 6 p.m. and 6 a.m. of the next day. So if you are following the due process of law, then you won't look into how they have been arrested. You'd only look that they are guilty. You'd only look at that they're guilty. But if you're following procedure established by law, then you look at whether the process to arrest them was accurate or not. How have they been arrested? Were they presented before the magistrate within 24 hours or not? Right? If they were not proven guilty, then in what conditions were they kept by the police, for example? Were they put in police custody or judicial custody? Is this clear or not?
Yes,
So
ma'am.
that is procedure established by law. Now write down one point, one last point write down, then we'll continue in the next class. This procedure established by law has originated from the British Constitution. Procedure established by law has been originated from the British Constitution, and due process of law has been originated from the US Constitution. Due process of law has been originated from the US Constitution. Clear?
Yes, ma'am.
Write down one more pointer. This is the last one. Procedure established by law checks whether the process is correct or not. Procedure established by law checks whether the process was correct or not. Whereas due process of law checks whether the law is correct or not. Due process of law checks whether the law is correct or not. Okay, just use some common sense and tell me, if you're following procedure established by law, you have to take care of the procedure as well, right? But if you're following due process of law, then you only have to act according to the act. The process may vary, okay? You may have flexibility. So tell me one thing, being a police officer, or being an executor or an implementer, where do you have more flexibility? Where do you have more scope to work according to, to work in your own way, according to your own uh, tricks and tips? Where do you think do you have more scope
And what
to work flexibly?
in what?
In due process of law or procedure established by law?
Due process of law is law.
Due process of law. You have more scope, more flexibility in due process of law, not the procedure established by law. There you have to take care of everything that is written on the paper. You have to act accordingly. Is this clear?
Yes, ma'am. And the ma'am, due process of law is when you take the action, and if you judge that it was a correct, it was
Yeah,
a
you're
correct
only
decision, and
considered
then
with the act. You're only concerned with the act. You
if the
only
act was
have
right or
to
wrong.
look whether the act is correct or not. But in procedure established by law, you have to take care of the whole procedure through which you are implementing that law.
Yes, ma'am. For example, like you said, ma'am, that the women can't be arrested like from 6 p.m. to 6 a.m. So like, for example, if if a person arrests a woman before 6 p.m., so that will be correct on the basis of the procedure established by the law. Like it will be correct, right, ma'am? Like it, if someone is, like, for example, if that woman is may cause any danger, after that they have to consult the government for like permission and take a
No, not the
lady.
government, not the government,
Sorry,
the magistrate.
magistrate.
The
The
magistrate.
okay, the
Yeah,
magistrate that.
who will come under the bureaucratic branch of executive.
Okay. Ma'am, so like they have to, after getting the permission, they have to take a lady police officer also, right, with them.
No, if they can't manage it, but if they have got that special permission, then they can arrest even in absence of a women officer.
Okay. And if
But they are exceptional circumstances. If it is very necessary to arrest one, in
okay.
exceptional situation can you be granted that leave?
Yes, so, and if without the permission, they have to take a lady police officer.
Yeah,
Okay.
but they ultimately will have to inform the magistrate.
Yes, sir. Okay.
Okay.
Yes, sir.
All right, that's all, Lobsang, for now. We'll meet in the
Okay.
next class, okay? And
Okay.
we'll move
Okay.
ahead and we'll see what system, due process of law, procedure established by law. Which system do we follow in India?
Okay, ma'am.
Okay, we'll
Okay.
discuss this in the next class. Just
Okay.
revise till here, okay?
Okay. Thank you so much, ma'am.
That's all. Thank you so much.